Well, good morning, good afternoon, good evening, wherever you are joining us from. I am Hannah Shea, World Law Group's Manager of Communications and Network Development. Thank you for joining us on today's webinar, which is hosted by World Law Group's Compliance and Investigations Group. Before I turn this over to Arnold and Porter, I wanted to give a really quick overview of World Law Group for those of you who may not be familiar with our network. World Law Group is a leading network of independent law firms across the globe with 61 member firms and more than 21,000 lawyers in our network. We collaborate globally in our 17 practice and industry groups, including this group, which is the newly formed Compliance and Investigations Group. And in 2020, we shared almost 3,500 referrals among our member firms. Just a few housekeeping items before we get started. You have been muted upon arrival and will remain so throughout the duration of the webinar. We will have time for questions, and I ask that you please post those in the Q&A feature at the bottom of your screen, and we will do our best to answer them all. If we don't get to your question for whatever reason, we will follow up with you after the webinar. So without further ado, I will now hand this over to our Washington, D.C. member firm, Arnold and Porter.
Thanks, Hannah, and good morning, good afternoon, everybody. It's good to be part of this session today. It's an important time in the world of corruption and anti-corruption and the kind of work we do. I want to introduce the four of us quickly. I'm John Macikas out of our Washington, D.C. office, and I'm colleagues and partners with Kathleen Harris, who's the head of our London office, and John Green in New York, along with Dan Bernstein. John Green, to start, was a former federal prosecutor out of the Eastern District of New York, which handles a number of notable foreign corrupt practices cases over the years, and he himself has participated in those. And he also worked out of the SEC's enforcement division, so he has kind of two important past hats to draw on, and you'll be hearing some of his insights today. Kathleen Harris is an esteemed alumna of the Serious Fraud Office in London and also the Attorney General's office, and has had innumerable experiences with both UK Bribery Act, FCPA, and other corruption matters throughout the world. Dan Bernstein is a prolific author and analyst of anti-corruption laws around the world, works closely with many members of our firm on cases around the world, focused recently in cases in Latin America and specific countries there, and we'll have some insights as we go along the way here. Kathleen, John, and I are the co-heads of the Arnold and Porter anti-corruption, global anti-corruption practice, and we'll try to really focus on matters that we think will be of most interest to all of you after giving you some kind of groundwork to make sure we're all on the same page in terms of the kind of the legal foundation here. But then we're going to get into trends that we see already over the past few years and what we expect to be coming in the coming years, which is going to be, I think, good news for firms like all of ours. So without further ado, we'll jump into kind of the program itself. So the anti-corruption laws that we're going to be, in some of the cases that we're going to talk about, will mostly focus on the US's FCPA, the Foreign Corrupt Practices Act, which has been the big gorilla in the field for decades, and the UK Bribery Act, which is another powerful anti-corruption law, which has led to a variety of important cases. But the United States and the United Kingdom are not the only countries in the anti-corruption world. As you all know, really every country is doing something at some level to pass laws and up their enforcement abilities, from China to Mexico. Many of you on the phone are familiar with Brazil's Clean Company Act. You have France expanding its efforts, Korea. You have the OECD Anti-Bribery Convention, just to name a few. So the world is focused on this for a number of reasons we're going to describe in a second. And don't forget that there are other local criminal laws that come into play in these investigations. For example, if the United States does not believes that there's an issue defining an individual as a government official, for example, they can bring in other laws to kind of tighten the noose on the target companies or individuals. For example, commercial bribery laws in the United States are often invoked by federal prosecutors. False statement laws, which are powerful felonies in the United States. Money laundering, some specific statutes that are, have interesting names like the US Travel Act and others. So don't forget, there are all often local criminal laws that come into play, not only American criminal laws, but the laws in place in the country where the bribery or corruption took place. So we'll get into a few more details of that in a minute. So why do these countries all now, in a concerted way, are they trying to enhance their anti-corruption abilities, their enforcement in their own country and then around the world? You will hear again and again from top Department of Justice and SEC officials, just because we're most familiar with those. Those are the speeches we most often hear here. But other officials from around the world will say the same things. Anti-corruption laws help kind of level the economic playing field in an honest way, so that governments will act more appropriately. For today's front page of the New York Times talks about the corruption in South Africa as a state capture place where ex-President Zuma was so corrupt, according to the reports, that there are now riots in the streets, and it's not the way modern government should operate. So government accountability is an important goal of anti-corruption laws. The concept of fair competition, honest contracting with state contracts, for companies to protect the company assets, where there are international companies operating in treacherous parts of the world, and transparency within these companies as they operate, and the kind of honesty that shareholders expect. And that's an important component for these companies to believe that they're not going to have to compete improperly through bribery to get important contracts around the world. Many years ago, I was an in-house counsel at Bechtel Corporation, and many decades ago, they were a company that often was losing giant contracts to other companies from other countries, where those companies were allowed under their laws to bribe foreign officials to get those contracts. Those days, we like to think, are over in terms of allowing bribery by other countries, but now the enforcement regime is really picking up in ways that is much more coordinated than in the past. We'll talk about that shortly. You'll also see the press releases that come out when cases settle, plea agreements are entered, repeating exactly what this slide talks about and the importance of honest corporate behavior around the world. And you will hear it firsthand when you meet with Department of Justice lawyers, when you meet with counsel from other countries, and again, day after day, case after case, these points are being emphasized. And we expect more emphasis, more resources, more actions by the Biden administration than we've seen the past 4 years, in a concerted way, in a coordinated way with other enforcement regimes around the world. And then a couple last overview points by me before I turn it over to John Green. Quickly, under the FCPA, you probably are aware there are two real separate provisions that are focused on by prosecutors and agents, and that's the anti-bribery provision, which prohibits bribing any foreign official for the purpose of influencing the official or securing an improper business advantage. Bribery is That's point one of the FCPA. Point two, the other really prong of it is the accounting provisions. Anytime there's bribery, there's likely to be improper accounting of that bribery by a company. They normally don't want to acknowledge it in their written papers. And so their issuers, public companies, are required to make and keep accurate books and records and to maintain an adequate system of internal accounting controls. And to prohibit, it also prohibits knowingly falsifying books and records or circumventing or failing to implement a system of internal controls. When you see these two provisions together, it leads to what you all are probably dealing with today, are companies' needs to have very aggressive and dynamic compliance programs. We'll talk about those as we go along, but those compliance programs really are put in place in part to make sure that these types of activities, whether it's bribery or improper accounting, don't happen, or if they do happen, that they're caught quickly and kind of nipped in the bud regionally before it spreads to a broader issue for the company. And then I think finally, so you want to make sure you understand where these provisions apply. Issuers under the anti-bribery provisions are subject to all of those provisions, and that includes all of their agents, their employees, their officers, their directors anywhere in the world. Domestic concerns are basically any company where the principal place of business is in the United States. And so those domestic concerns, any of their officers, employees, or agents are also exposed as US people and businesses. And then any person could be a foreign person taking acts in furtherance of a corrupt payment while in the United States or a territory of the US also becomes exposed. The authorities can charge any of these entities or individuals with aiding and abetting violations or conspiring to violate the FCPA. That could be a whole nother seminar, what the meaning of aiding and abetting is and the reach of conspiracy and aiding and abetting law. But there's a lot of powerful tools in the hands of prosecutors here and abroad to kind of ensnare wrongdoers. So the takeaway under the FCPA that we highlight here is that even if you are not a US citizen, even if you are not employed by an American company, and even if the conduct takes place entirely outside the US, there is exposure under the FCPA and kind of the long-arm jurisdiction of the reach of that statute, totally separate from whatever local laws would apply at the same time. And we've experienced this firsthand ourselves in different cases. For example, in the Big Embraer investigation a few years back, the one person, after a multi-year worldwide investigation, the one person actually charged and who pled, it happened to be our client. There's a good end to the story in terms of no jail time through active cooperation. But basically, he was a Rhodesian citizen, British, with a British passport, grew up in Rhodesia, fought against Mugabe's basically rise as a member of the Rhodesian Air Force, leaves and works in the Middle East, in Saudi Arabia, Abu Dhabi, gets caught up in a Saudi Aramco bribery scheme, and it's not any other country that pursues him but the United States, even though he had really nothing to do with the United States. The person who received the bribe, an official at Saudi Aramco, was prosecuted by Saudi Arabian authorities. And we'll get into the importance of what that means in a few slides down the road here, because it will show how current governments are apportioning responsibility for prosecutions more than they used to. So the US isn't going to just go after everyone. They will allow the Saudi Arabians, or actually encourage the Saudi Arabians, to pursue their own citizen, or Brazilian prosecutors to pursue the Brazilian wrongdoers rather than having the US do everything or the UK do everything. We'll talk about that more in a second. So the enforcement, as you've probably already surmised, of the FCPA is by both the US Department of Justice and the US Securities and Exchange Commission, and they're separate units within each of those big agencies that focus on anti-corruption. And the prosecutors and lawyers in those divisions are, well-trained, eager to make cases. And one of our senior associates just left to join the FCPA unit of the Department of Justice. And these are talented people that are ambitious and really do believe rightly in what they do.
Okay, thanks, John. So I think it's worth taking a little bit of time to talk about some of the key concepts here. I'm calling in from the New York office of Arnold and Porter. Behind me, you can see the Brooklyn Bridge. It's lovely out here, no wind at all. We'll go through this a little bit. So we'll go through each of these elements, and I won't spend too much time going over things that you know already, but I'll note a couple of things. These are the elements broken down of the U.S. Foreign Corrupt Practices Act. And we'll go through each of them, but I'll just pause for a second on the first one. It talks about paying, giving, offering, promising, or authorizing the payment of anything of value for the purpose, for a corrupt purpose to a foreign government official. I'll note, for example, the word offering there, the third one, as judges in the U.S. are fond of saying in most criminal trials, and particularly with respect to the FCPA, success is not an element of the crime. And so it is sufficient merely to offer a government official something of value, even if the offer doesn't work. There was actually a case where someone was impersonating an intermediary, claiming that they could have influence with a government official, received a substantial sum of money. In fact, the person was a total fraud. They had no influence with a government official. Nevertheless, it was illegal to have paid that fake intermediary for the attempt to influence a government official. And so I think that's an important thing to remember. Even if you fail, it doesn't make for a very good story, but it certainly makes for a crime. Go ahead to the next slide. So let's break them down. Anything of value is an incredibly broad concept. Like many of you, I have clients that frequently say, don't worry, I'm not going to violate the FCPA. It's not like I'm going to deliver a bag of cash to a foreign government official. And of course, if that was the only thing the FCPA prohibited, we wouldn't really have FCPA cases. No one's that stupid. That almost never, I shouldn't say no one, very few people are that stupid. It almost never happens that people deliver bags of cash. But there are all sorts of other ways that you can attempt to influence a government official that are more subtle, harder to detect, and equally as illegal. Contributions to charities that are closely affiliated with the government official, no-show jobs for a family member of the government official, unpaid internships for the sons and daughters of government officials, a term that many of you I'm sure have heard before. There was a case involving a government official's daughter who had her honeymoon funded by a business looking to obtain an advantage. Sponsoring travel beyond what is necessary to demonstrate products or services. And so there's been some guidance that's been put out. The SEC has said the following questions are ones you might ask when determining whether, look, is there anything of value here? One, was the thing requested by the government official, right? That's something to think about. Did the company believe it would help them obtain an improper business advantage? Were you providing something to demonstrate the value of your product, or were you providing it simply to benefit the government official? Did the company have any procedures that were followed in connection with the providing of the thing of value? And was it accurately recorded, of course, in the books and records of the company? Another key concept, what is a government official? Government officials include, obviously, the government, employees and agents of any government entity, elected officials, party officials, candidates for office. I think, as we think about our own countries, we're all pretty adept at figuring out where the government ends and where private industry begins. But when we think about other countries, it's often more difficult to figure that out. It's not always obvious. And so there's been a lot of questions that have been asked over the years, such as when we're talking about an entity that is not strictly speaking a government agency, questions arise as to whether, for example, the entity is owned or controlled by the government. There was a case in Florida involving bribery related to the telecommunications company in Haiti, and it was a challenge. One of the challenges that the court had to confront is, was this telecommunications company in fact a government official, or was it just a private telecom company? And one of the key questions some of the key questions that the court asked were, does the entity perform a function that the government treats as its own? Does the government designate the entity as the one to perform that function? Does the government grant a monopoly? Does the government get to say who's going to be the telecom company? Does the government have a majority interest in the company? Not dispositive, but it often can be. Can the government hire and fire that entity's principals? Very important, feature in demonstrating control. Do the profits go to the entity? Do the entity's profits go to the government, or are they retained by the entity? And conversely, will the government backstop the entity to the extent it has losses? And we've seen, at least in the past financial crisis, a lot of entities that we would think of as private, and I'm convinced are still private, backstopped by the government entity. I don't think that, for example, the U.S. auto industry was converted into a government entity because the government was willing to backstop and provide advantageous loans to help keep the industry afloat, but it is a factor. And so, I have found, I usually say this to compliance officers and in-house counsels when talking to them. I say, if you have a business person who is asking you questions and trying really hard to figure out if they're working with a government official, you might want to caution that business person and say, look, if the idea is you're trying to figure out whether you're working with a government official, you may want to just press pause on whatever activity you're engaged in, because there are laws, as John alluded to a few minutes ago, that prohibit commercial bribery as well. And so you don't want to be engaging in any type of bribery, whether it's with respect to a government official or not. Directly or indirectly. I continue to believe that this is the toughest concept and the biggest risk area for companies. As we'll talk about on this slide and the next one, this concept of third-party agents, and whether a company or an executive is able to say, look, I gave money to a third-party agent, I didn't ask questions, I don't know what they did with it, that sort of thing. That's what this funny cartoon is designed to illustrate. That's not going to work. The concept of conscious avoidance, which is a US law concept, but I know it exists elsewhere, is built into the statute. I mean, you can't simply pull the wool over your eyes, or if you like another metaphor, the one that's often used in US law is called the ostrich, the bird that sticks its head in the sand, to say, I don't want to know what's going on. I'm just going to give some money to someone and hope I get the contract that I've been trying to get. That's not gonna fly, and you're going to be deemed to have known about where the funds were ultimately destined. Yeah, and as I mentioned, the third-party relationships are, in my mind, the biggest risk area. And these are some of the factors that courts have looked to, and that the SEC and the Justice Department in the US look to when saying, look, you've got red flags here, and you've got an obligation to run it to ground. Now, many of these will have explanations other than foreign bribery, right? Vaguely defined services. If a company is trying to break into a new country and wants a consultant to help show it around, it may have a sort of open-ended type of consulting agreement. That also might be the type of agreement that is a front for foreign bribery. We don't always know, but it's the kind of thing that's a red flag, and the kind of thing that when you have that going on and you don't really know what the third party is doing, the SEC and the US Justice Department will expect you to run that to ground and to know exactly what this other party is doing. Travel, gifts, and entertainment. This is another one where we get a lot of questions sort of on an ongoing basis. My general rule of thumb is, small tokens. There's no de minimis exception to the FCPA, but there are generally speaking, a small token, while not a de minimis exception, is not going to be seen as something that was designed to corruptly influence a foreign government official. It's hard to imagine a foreign government official would be influenced by someone picking up cab fare, providing them with a coffee mug with the company logo on it, that sort of thing. I usually tell clients, if this is something with the company logo on it, it's going to be fine. Obviously, you don't want to put the company logo on a Ferrari and give it to them, but generally speaking, the types of things you would put a company logo on are going to be perfectly fine. Donations and sponsorships can be okay, but again, you want to have a good understanding of where the donations are going. Is this a genuine charity, or is it a front or something that is really closely affiliated with the government official, such that the government official is personally receiving a benefit from the donation, as opposed to it going to the charitable beneficiaries that it ought to go to. I'll move quickly through this. So facilitation payments, this is one that we often get questions about, because it is often the exception that is deemed to swallow, that can be viewed as swallowing the rule. So facilitation payments are small sums of money that are paid to expedite the performance of certain government actions. And there's a few key things to remember here. First, as you'll see at the end of the sentence there, a lot of other anti-corruption laws, such as the UK Bribery Act, prohibit facilitation payments. So you want to do a careful analysis of what anti-corruption laws govern here, not just the FCPA. Second, the key to knowing whether something is a facilitation payment and not a bribe is whether the action it seeks to facilitate is a routine one, or whether it's something that involves discretion. And there's been guidance about what's considered routine and what's considered not routine. And for example, processing visas, providing police protection, initiating mail service, connecting utilities such as the telephone, power, water, those are going to be considered routine. But things like awarding a contract, or deciding which company gets to do this or that, gets a permit to build or do engage in a particular business in an area, those aren't routine. So even if a low-level government official is vested with that authority, sometimes it's a hard line to draw with respect to facilitation payments. And I think if you leave here with one concept about facilitation payments, I would say the concept is that they are very narrowly construed under US law, and I would be very careful in authorizing something based on facilitation payments. That, and they're prohibited under many other laws, including the UK law. Mergers and acquisitions. A lot of times companies are acquiring, a US company might be acquiring a foreign company, and they may not have perfect visibility into what actions the company has been engaged in the past. This is an issue that, frankly, the Justice Department has put out some pretty decent guidance on, as has the SEC. And what they've said is basically, if you're conducting thorough diligence, both pre and post acquisition, right? Because sometimes you don't always know everything before the acquisition. Sometimes you need to finish up the diligence afterwards, and it's genuine. They will not pursue an enforcement action, even if a company inherits FCPA liability based on the company that it acquires. And the other thing to note is there's no retroactive liability. So if a company committed an FCPA violation, that violation is complete, it is then acquired by a US company later, you don't retroactively get FCPA liability. It's done and dusted, so to speak. And lastly, penalties. I won't belabor this point too much, but you've seen, I think if you look at what the penalty provisions under US law, it looks relatively formulaic. And you might think, well, how do we get to these enormous sums with this relatively formulaic penalty amount? And the answer is that first bullet there, up to twice the gain. And frankly, it's often just a negotiated number. How much a company gains from a particular project is very difficult to determine, and is just often the product of negotiations between that company's counsel and the government's counsel. And that's why you see numbers that sometimes just don't seem obvious as to how it is they came up with that particular number to settle the case. Compliance monitors, these can be quite challenging for companies years and years in the future, but it's certainly something to think about as well. And so with that, Dan, let me turn it back over to you to talk a little bit about some of the current trends we're seeing in FCPA enforcement.
Yeah, thanks.
John, did you want to introduce?
Yeah, I'm going to introduce the topic in 1 second. Just to add one comment to what John just mentioned, for individuals who are prosecuted separate from companies under the FCPA, the bribes involved in some of these big international contracts can be substantial, as you well may know. And under the individual sentencing guidelines, someone involved, for example, if it's a $90 million just economic contract, not the amount of the bribe can only be a few $100,000. The guidelines will focus on the value of the contract, which very quickly, and we've experienced it, can have an individual facing, at least on paper, life in prison, which can be daunting for that individual and daunting for defense counsel, but gives the prosecutors a lot of leverage to negotiate a plea agreement with that type of and get cooperation. So there is very severe penalties for individuals under the U.S. sentencing guidelines. So now, as we turn to trends, which Dan is going to get into in a second, and then what we should do too. There is one question actually I see that's come in on the Q&A that really just quickly, and maybe anyone, John or Dan or Kathleen may want to jump in on this one. But the question comes in from an individual that says, any thoughts with the strengthening of third-party risk management programs? Any thoughts on the interplay between anti-corruption laws and regulatory mandates globally with money laundering and illicit proceeds of cyber attacks? And that to me strikes me as it's a pretty complicated question. My initial observation is cybercrime is a whole nother array of statutes that are actively being enforced. And it's clearly a real issue with the ransomware attacks and that are happening around the world with company after company. Money laundering is a very powerful statute that has high jail exposure in the United States and can be used as leverage to get a plea to a lesser charge. It strikes me the question is leading to a lot of the compliance efforts that companies are involved with to try to reduce cyber attacks, to try to make sure any money laundering that a financial institution has going on, it's caught quickly by its systems. But John or Dan or Kathleen,
I was just going to say, I mean, it's quite common for money laundering investigations to sit alongside bribery and corruption investigations, I think both in the UK and globally. And I think that trend is set to increase. Certainly in Europe, you've seen it increasing, and I think I'd say the same about the UK, i.e., I think that things are starting to become finally a bit more joined up by investigative agencies. And I think tracing the money, however that happens, is always, I think, front and foremost of any investigation.
And I'll quickly just add the corporate compliance perspective. I think there are a lot of very large companies, for example, like global financial institutions that may have separate anti-corruption compliance programs and anti-money laundering compliance programs, and individuals who specialize in those areas. But then there are a lot of companies, particularly smaller companies, that combine the functions and have people who are individuals who are focusing both on anti-corruption laws and money laundering laws, because as John and Kathleen have said, there's so much overlap there. Oftentimes anti-corruption charges and money laundering charges are brought in the same case or involve the same set of underlying facts. And we often see companies, when giving compliance training, addressing anti-corruption laws and money laundering laws together. So I think it's true that there is a lot of overlap, and we would certainly recommend that companies, when developing and implementing their compliance programs, think about their exposure to both. And of course, cyber attacks are a cutting edge issue that can implicate both of those laws and a host of others, as John said.
Yeah, and before Dan gets into some of the weeds here and interesting weeds on trends, the broader topics that we're going to cover are you'll see the large financial penalties of years past have become even larger and consistent. You know, it seems from administration to administration, they continue to grow. The number of prosecutors and agents continues to grow. So we expect that trend to continue. There's increased international coordination that you'll hear about. We've already mentioned. There's interagency coordination that you'll hear a little bit more about. There's focus on Latin America that we'll talk about, but don't think that there isn't focus on Africa, Middle East, China, other Asian countries, and European countries. So it is worldwide, but there are different investigations and enforcement can kind of grow within a certain region. We've seen it in Brazil, where the prosecutors really have gotten more emboldened and more experienced, and therefore more effective. They're going to be, as a consequence of a lot of what we've described in terms of the penalties at risk here, the punishments for individuals, the financial problems for companies, huge incentives for cooperation that you'll hear about. Dan and John have already, I think, touched on it. The corporate compliance programs that are increasingly important. They must be dynamic. They can't be static. You'll hear about that. And finally, collateral litigation in terms of class actions, securities, class actions, RICO, international arbitrations. There are many ways a company can feel pain separate from the direct bribe or accounting inquiry. So Dan, to you.
Thanks, John. Larger financial consequences of bribery is something that we're seeing. Here is a list of the 10 largest US monetary sanctions by entity group. And by entity group, we mean, parent and subsidiaries. Sometimes it's a parent company that bears all the pain. Sometimes it's a subsidiary. Sometimes it's both. And what's interesting here is that of these top 10, 8 of the largest FCPA settlements ever have been within the last 5 years. Odebrecht, a Brazilian company, actually went bankrupt in large part as a result of this massive exposure to FCPA liability and also exposure to anti-corruption laws around the world. Goldman Sachs and Airbus, number 2 and number 3 on this list. These massive penalties were agreed to just last year. Those were 2020 settlements. A few of these others were in 2020 and 2019 as well. So we're seeing year by year the overall penalties that the US government and other authorities are extracting from these companies getting higher and higher. Now, of course, the DOJ and the SEC aren't just bringing billion-dollar cases. They're bringing cases, with settlements for millions of dollars. They're also in some cases bringing settlements for hundreds of thousands of dollars. That doesn't mean you can't have exposure for smaller amounts. As John Green said earlier, there's no de minimis exception to the FCPA. At least in theory, you could be liable for a criminal violation of the FCPA for a payment worth hundreds of dollars. But interestingly, some leading officials at the DOJ have said in public statements, we're not really focused on bringing criminal enforcement actions for, a game of golf or, one meal or, one small gift here or there. But, when there's a pattern of giving these smaller gifts over and over and over again, authorities may be interested, and we've seen cases like that, in addition to these billion-dollar cases. Okay, another trend that we've seen and that has been alluded to multiple times so far today, because it's important, is international cooperation. This is something we've been seeing for years, something we saw in the Obama administration. It's something we actually saw a lot of in the Trump administration, to some people's surprise. Both of these massive enforcement actions here actually were brought under the Trump administration. And we wanted to highlight a couple here. Here's this Airbus settlement that involved $3.9 billion in global penalties to resolve foreign bribery and an ITAR case. ITAR, for those who don't know, is international trafficking case brought by the State Department, involves export controls. Oftentimes there's overlap between anti-corruption cases and export control cases, but it wasn't just the US Department of Justice. Here in its press release, the Department of Justice acknowledged and expressed its appreciation of the significant assistance provided by France's Parquet National Financier, I hope I'm pronouncing that right, and the UK's Serious Fraud Office. So it really was a tripartite settlement. With respect to the Goldman Sachs multi-billion-dollar settlement, I included this excerpt here, and I know it's very hard to read, but that's actually on purpose, because I wanted to use this to illustrate, the breadth of international cooperation that we're increasingly seeing. Here, the US Department of Justice specifically noted in its press release that we appreciate the significant assistance provided by the US Securities and Exchange Commission, the Board of Governors of the Federal Reserve, including the Federal Reserve Bank of New York, the New York State Department of Financial Services. That's just the alphabet soup in the United States. The alphabet soup abroad that the Department of Justice acknowledged was the United Kingdom Financial Conduct Authority, the United Kingdom Prudential Regulation Authority, the Attorney General's Chambers of Singapore, the Singapore Police Force, the Monetary Authority of Singapore, the Office of the Attorney General of Switzerland, the Judicial Investigating Authority of the Grand Duchy of Luxembourg, the Attorney General's Chambers of Malaysia, the Royal Malaysian Police, the Malaysian Anti-Corruption Commission, the Ministry of Justice of France, the Attorney General's Office of the Bailiwick of Guernsey. This is quite the alphabet soup. It's quite a laundry list here, but every single one of these enforcement authorities in all of these countries were involved in bringing this case against Goldman Sachs. So this really, again, illustrates the breadth of international cooperation we're seeing. This is not something you would have seen 10 or 20 years ago. Similar to international coordination, we're also seeing interagency coordination. Again, this isn't something new. We've seen interagency coordination in the United States, not just between the Justice Department and the SEC, which have statutory authority to bring FCPA enforcement actions. We've also seen actions involving the Treasury Department, where maybe there's sanctions issues. We've seen actions involving, for example, the CFTC, the Commodity Futures Trading Commission, for issues with financial institutions involving commodities. And just this past month, on June 3rd, 2021, President Biden issued this memorandum, which you see here on the screen. It's a memorandum on establishing the fight against corruption as a core United States national security interest. And pursuant to this memorandum, President Biden ordered an interagency review. And that interagency review will include all of the offices and agencies listed here. It's going to include the Vice President, the Department of State, the Department of Treasury, the Department of Defense, Department of Justice. The list goes on. President Biden wants every single one of these offices and agencies to focus on the fight against corruption, which he himself has labeled as a core United States national security interest. So what might this mean? Something new is the involvement of intelligence agencies, the Office of the Director of National Intelligence, the CIA. We're expecting them to focus on corruption, developing intelligence, building cases, thinking about these issues from a national security perspective, as well as just sort of a business securities regulation perspective. There haven't been a ton of corporate FCPA enforcement actions so far in the Biden administration, and that's not particularly surprising. It often takes administrations a while to get their nominees through the confirmation process, get their new program priorities and policies in place. but we expect anti-corruption enforcement activity to really pick up in the second half of the year and over the next 3.5 years of the Biden administration. Here, another trend that we're seeing is a focus on Latin America. We're seeing this both through the enforcement actions that the SEC and DOJ are bringing. We've excerpted some here. Earlier this year, the SEC, for example, charged the company Amec Foster Wheeler with FCPA bribery violations related to a Brazilian bribery scheme. This is just the latest example of the many cases that have been brought out of the Petrobras Operation Car Wash scandal in Brazil, which is still going, even though the Operation Car Wash task force officially is winding down in Brazil. Investigations that started a while ago, are continuing. Authorities are still developing information, still bringing cases. The statute of limitations has not yet run on all of them. So we're seeing a lot of cases out of Brazil. Another example here on the right, you see a businessman. This is an individual was sentenced for foreign bribery and money laundering scheme involving Ecuador officials. We've seen a lot of cases coming out of Ecuador, including multiple cases involving Ecuador, state-owned oil company there. You may be noticing a theme here. There are a lot of cases in the oil and gas industry where government involvement is often heavy in other countries. Not only Petrobras in Brazil and Ecuador in Ecuador. We've seen a lot of cases involving state-owned oil companies in Venezuela. Venezuela has really been a focus. And in the middle here, we have a recent news article from a trip that Vice President Kamala Harris took to Latin America. And as you can see, with Kamala Harris visiting Guatemala and Mexico on her very first foreign trip as vice president, the Biden administration announced new measures to fight smuggling and trafficking and hopes to announce additional anti-corruption efforts. So the Biden administration has very explicitly said that they believe corruption is a very serious issue that needs to be tackled in Latin America specifically. As a law enforcement matter and also as a national security matter. So we expect to see additional enforcement actions coming out of Latin America, not only in Latin America, there are other areas around the world where we've seen multiple enforcement actions of late, but Latin America, based on the public statements, really seems to be a focus of the Biden administration for now. So companies doing business in Latin America should very much be attuned to that. Another trend we've seen is incentives for cooperation. Just a few years ago in 2017, the US Department of Justice issued a formal FCPA corporate enforcement policy, which it incorporated into the official Justice Department manual that applies to all federal prosecutors. And this policy creates a presumption that a company will not be prosecuted absent aggravating circumstances if it, one, voluntarily discloses misconduct. In other words, if the company comes to the Justice Department, not the other way around, not if the company waits to get a subpoena or an information request. Two, the company fully cooperates with the government's investigation. And that means, sharing information. That means making witnesses available. That means providing documents. That means answering questions. And then thirdly, the presumption that a company will not be prosecuted applies if the company remediates any problems. First and foremost, that means stopping whatever the misconduct is. If there have been bribes paid, making sure the bribes are no longer being paid, but also remediation in terms of enhancing corporate compliance programs, making sure policies and procedures are in place. We'll talk a little bit more of that. Importantly, under the policy, companies also may receive up to a 25% reduction in penalties if they cooperate and remediate but don't self-report. We've dealt with this ourselves in multiple cases, where a client of ours got a subpoena from the SEC or the DOJ or both got even an informal information request, and then ultimately settled, even though they didn't self-report the misconduct or the alleged misconduct. We've helped these companies navigate through the FCPA corporate enforcement policy, help these companies cooperate with the Justice Department, provide information, help these clients remediate the misconduct, develop their compliance program. And we've seen very tangible results for that, up to a 25% reduction in penalties. And 25%, when you're talking about $100 million fine, that's $25 million. If you're talking about $1 billion fine, it's $250 million. There can be very significant financial benefits for cooperating and remediating. And we're seeing this more and more. It's sort of becoming the exception rather than the rule for companies not to cooperate and not get this credit.
Hey, Dan, sorry, if I could just jump in for 1
Yeah,
second.
absolutely.
I think this is a really important slide. And if I always say, if you take away one thing from this, let it be this. If there's a few things you take away, I think, there's been a fair debate here in the US about who should be punished for corporate malfeasance in various contexts, right? There was a time when there was a view that corporations should pay a heavy price. The pendulum has swung back and forth on that a little bit over the past couple of decades. But I think if you take a step back and really look at it at a macro level, what you'll see in the US is a steady march, at least over the past decade or two, towards individual liability. And I think now more than ever, corporations are heavily incented, and it is the official policy of the government in the US to heavily incent companies to basically give up their employees that engage in wrongdoing in exchange for significant leniency. The example I always like to use is for those of you who practice in the antitrust space, in antitrust law, there's a flat out amnesty, right, under certain circumstances for companies that report. FCPA hasn't quite got there, but it's getting closer for the reasons exactly what Dan is talking about. And so I think this is just a recognition of two things. One, that the US government has sort of recognized that, well, not much is gained when we punish a company. We punish their shareholders, but frankly, the wrongdoers are usually long gone, right? And so we don't really teach a company a lesson. And two, FCPA violations are just really hard to detect. And if we want to detect them and prosecute wrongdoers, the only way to do it is to put the screws to the company and give them the incentive to find the bad guys and give them up and turn them over to the government. So sorry about the long-winded interruption there, but I really think this is a critical takeaway here, that rooting out, forcing the companies to take this seriously and to tell the government about employees who have engaged in wrongdoing is a significant policy shift for the US government.
Yeah, absolutely. Okay, moving on to our next trend, focus on corporate compliance programs. And this is really a developing area that we think has taken on new life in recent years. Last June, just over a year ago, the U.S. Department of Justice Criminal Division issued new guidance on how it evaluates corporate compliance programs. And we know from our own experience with clients that authorities at the Justice Department are really following this religiously. This guidance on evaluating corporate compliance programs lists dozens and dozens of questions that companies should consider. And in our experience, when forced to talk to the Justice Department about the state of a compliance program, we get those questions and we get follow-up questions, to what's listed on paper here. So companies would be very well advised to familiarize themselves with it. Now, not every question is going to apply to every company. And I think the Justice Department recognizes that. But there's very helpful guidance that didn't exist a few years ago for companies. And in deciding how to treat a company under investigation, the Justice Department will evaluate the company's compliance program both at the time of the offense, when the misconduct happened, even if it was 10 years ago, the Justice Department will look back in time and say, well, was there a compliance program in place? If there was a compliance program in place at the time, say 10 years ago, that was intended to detect and prevent the misconduct, the company may get more lenient treatment than if it had no compliance program at all, and hadn't trained employees on how to comply with the law. So Justice Department looks backwards in time, and then they also look at the present, at the time of the charging decision. The Justice Department will ask, what does the compliance program look like today? Does the company today have policies and procedures in place to stop this sort of thing that happened in the past? The three fundamental questions that the Justice Department asks, and this is at the very beginning of their formal guidance on the evaluation of corporate compliance programs. The three fundamental questions are: one, is the corporation's compliance program well designed? Essentially looking at the program on paper. Two, is the program being applied earnestly in good faith? And this goes beyond what's just on paper, looking underneath the hood at how it's actually working. And then three, does the compliance program work in practice again? So earnestly in good faith, goes to sort of, how hard the company's trying. Does the company's compliance program work in practice? Goes to sort of actual effectiveness on the ground. More specifically, and we've talked about some of these, but just to give you a sense of, what the authorities look for, they may ask both private and public companies. Again, it's not just public companies that issue securities that are registered with the U.S. Securities and Exchange Commission. The Justice Department, will ask these questions about private companies as well, even small companies. What policies and procedures do they have to prevent and detect misconduct? What compliance training have they given? Are they giving continuing advice? This goes to John Nasikis's point about compliance programs being dynamic. It's not just about giving one presentation on the FCPA and then never doing anything again. You need to be continually giving and updating training, making resources available for employees who have questions. Third-party relationship management, as John Green talked about, is very much a focus area for authorities, since a lot of the problems we see arise out of third-party relationships, where a third-party agent, broker, consultant, is doing something they're not supposed to be doing. The Justice Department wants to know, how are you managing these relationships? Are you doing diligence on the third parties you're hiring? Are you putting provisions in your contract with these third parties requiring them to comply with anti-corruption laws? Are there consequences under the contracts for a third party not complying with anti-corruption laws? Is that a basis for termination of the relationship? And also, after you sign the contract, are you monitoring what your third parties are doing? Are you keeping an eye on them? Or, conversely, are you putting your head in the sand, which the authorities don't believe is okay? It's not a defense to the FCPA under, under the statute, or certainly under DOJ's guidance. Authorities will also look at internal reporting mechanisms. For example, do you have a whistleblower hotline? Is there a number you can call? Is there a box where you can drop a complaint? Is there an email address you use? How do these things get reported? And are the mechanisms for reporting confidentially and protecting whistleblowers? I'll just speed through the rest here. The Justice Department also will look at incentives and disciplinary measures. Someone violates a company policy. Are there consequences? Do they get disciplined? How is misconduct remediated? And then also, what resources do you have, for auditing, for documenting, for analyzing compliance efforts? And this is very much going to vary by company. It's not formulaic. The Justice Department is going to expect a massive multinational company to put a lot more resources toward anti-corruption compliance than, a company with 20 employees. Okay. John, I know we need to switch to Kathleen soon, but you just want to touch on this Morgan Stanley case?
Yeah, sure. I'll just say very briefly. This is the case is actually a great example of what I was talking about the incentives to have companies have robust programs, and when they confront some of the red flags we were talking about before, to conduct a thorough investigation, root out wrongdoing, and cooperate with the government. The case here is United States against Garth Peterson. One of an employee of Morgan Stanley actually, was convicted, and sentenced to prison. Morgan Stanley got zero, absolutely no penalty. no consequence whatsoever, other than obviously they had to pay attorneys to cooperate with the government. This is a pretty good example of the government being sensitive to the message it sends. And I know it pretty well because I was one of the prosecutors with the government who was involved in the investigation of this case. And I don't think I'm giving anything away when I say the idea here was very much to send a message to companies situated like Morgan Stanley that when you behave this way, cooperate with the government, aggressively root out wrongdoing, have a robust compliance program, in the first place, you are going to come out in a very good position. And Morgan Stanley indeed did come out in a very good position at the end of this.
Okay, and then the last trend we wanted to talk about is collateral litigation, because in addition to investigation costs, which really can be massive, particularly if it's an investigation in multiple countries around the world, multiple units of a company, the investigation costs, not just lawyers, but others too, can be very high. And in addition to remediation costs, cleaning up any problems that you find, and in addition to monetary sanctions, the criminal penalties, civil penalties that authorities may impose. Companies and individuals that come under an FCPA investigation now often face collateral civil litigation arbitration, including shareholder derivative suits, and those may come in the form of claims against officers and directors for breach of their fiduciary duty, for fraud, for wasting corporate assets. Public companies, particularly public companies listed in the United States, very often face enterprising plaintiffs, lawyers who are incentivized to bring securities class actions under federal securities laws, for example, for not disclosing, information about certain material contracts, or making, false or misleading statements about the company's compliance program or what's going on in certain regions. Companies, public and private, also face RICO claims. RICO is a federal statute originally created to go after organized crime like the mob, but now increasingly used as a weapon by foreign companies, competitors, counterparties in cases involving corruption and business matters. But also contract claims. There can be breach of contracts, fraud claims related to two private companies' contracts when corruption's involved. And lastly, another trend we're seeing is whistleblower and retaliation claims. These can be whistleblower claims under federal securities laws, or they can be retaliation claims, or discrimination claims under various state laws in the United States. All of this can be very costly, even if a company is innocent, even if they don't pay a criminal fine, they still may face any number of these collateral litigations. All right, we've taken enough time talking about the US. I think we'll turn things over to our colleague across the pond in London, Kathleen Harris, to talk a little bit about.
Hey, thank you, Dan, John and John. The reality is that my colleagues have mentioned the words cooperation, global approach, compliance, remediation, and all of the above, and everything they've said actually applies to the Bribery Act. So a little over, 10 years ago, the Bribery Act was introduced into the UK. And really at the time when the government was thinking about introducing this act, it was looking at some of the large sanctions and penalties that Dan's touched on that were introduced in the US for companies who found themselves falling short of the standards required under the FCPA. And the criticism 10 years ago of the FCPA really was quite heavily about the fact of lack of accountability for individuals. And I find it quite interesting that 10 years on, we have the Bribery Act. And the area that I think is now the sort of subject of the most conversation is what's happening to senior officials within companies. And why haven't there been any prosecution of any individual under the Bribery Act related to DPAs that have been agreed? So I don't want to go through, I don't want to make this a law lecture, but certainly in terms of the Bribery Act, the significant thing that it did was simplify and update the law in relation to the fight against bribery and corruption. And then it also introduced a corporate offence of failing to prevent bribery and corruption. And the only way a company could avoid a penalty for that offence if they were found to be liable was by showing that they had adequate procedures. And what the government did in the UK is effectively, for the first time, reverse liability and place emphasis on a corporate to show why, in effect, it shouldn't be prosecuted. And in truth, what that led to was a growth in compliance work and the compliance industry, because I think for the first time, companies really had to start to grapple with what procedures they really had in place to prevent bribery, but not just having them, but making sure that they were monitoring them, making sure that they were continually fit for purpose, and also making sure that the board were supervising them. And although we haven't had any case law in the last 10 years in the UK demonstrating what adequate procedures will be, I think by the DPA settlements that have gone through, and there's been 10 of them, what you can see is that the regulator will look very closely at the robustness of the procedures that are in place. And interestingly, what they are starting to do more and more is ask about the senior individuals and their roles in making sure those procedures have been complied with. And the trend that we're seeing around sort of reversing, if you like, this burden of proof for corporates is the process has been adopted in relation to failing to prevent tax evasion. And John earlier on was touching on sort of money laundering. And we're starting to see now, and the Law Commission are starting to look at it again, is whether that type of liability can be extended to all economic crime offences. And equally, in relation to the financial regulator sector, where they have something called the senior managers regime, where senior managers are held account for, if you like, junior people doing things wrong, whether that can be extended across, again, to sort of deal with economic crime. So I think the trend that you are really seeing now is one where companies are going to be sort of fully held to account for all sorts of economic crime offences, not just bribery and corruption, but also there's going to be, I think, over the next 10 years, greater emphasis on senior individuals in an organisation, and similar to the senior managers regime, being held account for any wrongdoing that takes place under their watch. When Dan was reading out the different agencies that were involved in the large settlement, I mean, it's not unusual. In fact, it's more common in the UK that when you have large investigations, there will generally be a joint approach from the regulators in the UK. And what it means is that really the whole host of the offending will be examined. We go on to the next slide, please. Again, I'm not going to labour the differences between the FCPA and the UK Bribery Act, but one that is worth calling out and mentioning, because it's a theme that's developed as we've been talking today, is around cooperation. And I've put on the slide at the bottom, you'll see that there isn't, you know, resolution by DPA is possible both in the UK and the US. But what is slightly different is how the UK approaches cooperation, because in the US, I think that there's more of an ongoing dialogue with regulators, whereas in the UK, the judiciary, a judge has to be involved fairly early on. It's a judge that agrees and decides that a case is suitable for a DPA, as opposed to the regulator. And also, although self-reporting has played, a huge, I think, part in some of the settlements in the US, there were 2 settlements in the UK where there was no self-reporting at all. But what happened was the SFO were keen to consider the efforts that, although it wasn't self-reported and although they'd already opened an investigation, what effort the company had gone to since the matters had come to light. And also, what's a hallmark of the 10 DPAs that have been so far taking place in the UK is there's this agreement to assist with the investigation and prosecution of individuals. And like I've said, I expect to see that increase over the next coming years. And then finally, I think, because I know that we're sort of shortly up to time, and I don't know where you are, but it's certainly a warm, sticky day in the UK, so I don't want to melt on the screen for you all. But I was going to say that as recently as the 4th of July in the UK, there's been mentions of bringing forward a kind of failure to prevent human rights and environmental due diligence for corporates. And there's been quite a few organisations lobbying the government to bring forward, I think, a similar act of parliament as some of our, I'm going to still say European colleagues, so similar countries, I think France, Germany and Norway have already enacted a provision for that area of potential offending. So overall, I think that the Bribery Act has set a trend for codifying, for simplifying criminal behaviours within a corporate setting. It's starting to set the tone for holding individuals to account, and has made, I think, very clear the trend that we've all talked about, or trends around compliance, global appreciation of each other's regulators, the working together, and then the general cooperation, not just with other regulators, but those advising companies before regulators to achieve what will be the best outcome for a company in those circumstances. And I also finally would say that compliance, although some companies would argue it's not a sort of money-making feature of a company, I think over the last 10 years, it's an issue that now is regularly addressed at board meetings, and rightly so. And I don't think that that trend will decrease, particularly if the emphasis starts to go a bit more firmly and a bit more clearly senior leaders within organisations. All right, so I think I've done that and brought us into time, which will now, I think, lead us on to questions. As my colleagues know, I could sort of talk for Britain all day long. And like many of the topics that we've touched on today between us, some of them are worthy of separate webinars on their own. I mean, when you look at adequate procedures, when you look at compliance programs, when you look at training, when you look at the trend we're seeing now in relation to the COVID-19 pandemic, whether that will lead globally to more enforcement activity in the years to come. But like I say, I mean, for me, it's definitely the failing to prevent regime is here to stay. And I think that that's the biggest trend that's going to grow in sort of legislative action over the next 10 years. So thank you for listening to me.
Thanks, Kathleen. I could listen to you all day, particularly with your British accent. So, no, but on behalf of our team, we thank you. We obviously will answer additional questions you may have separately offline. I don't see anything else posted. My only parting thoughts are, with the trillions of dollars that are now kind of coursing through a kind of an awakening world, there's going to be just huge amounts of fraud and corruption going on, unfortunately, despite the best compliance programs in place. And so there's going to be a lot of work to come. And our current Attorney General, Merrick Garland, we're proud that he's an alumnus of our law firm, a tremendously highly regarded lawyer, jurist, and now Attorney General, bringing in some of, frankly, the best thoughtful, aggressive talent in U.S. In U.S. law circles. Those folks are about to be put into positions as the U.S. attorneys in leadership at Main Justice here in Washington. And you should expect a robust, serious, integrated approach that's going to ramp up activity against companies and individuals worldwide. So with that, from me, thank you. And I believe Hannah from the World Law Group may have a couple closing points, but we really appreciate your time today and agree it's a hot one out there. And thanks, Kathleen. None of us are melting.
Take care.
Thank you.